I would like to go ahead and get started. And again, everybody, thank you so much for joining us on the Transportation and Logistics Clubhouse. This clubhouse got started because I needed some advice on how to transition from corporate America, where I was dispatching, to doing it as an independent dispatch agency. And, I was very, very fortunate enough to meet some very wonderful people who are willing to share information with me. And, that really became the precursor to Atlanta Dispatch, which I'm loving today, is thriving, growing, great relationships and everything. But it was using a platform like this to learn about the basics, the fundamentals of doing it as an entrepreneur. And now, I feel as though one of the sections that we don't talk about enough, I guess, is one of the most fundamental parts of onboarding with a brokerage. So onboarding a carrier to a freight brokerage, which is broker carrier agreements and things of that nature. What are those clauses really saying? And, I'm very happy to be talking about that today. But before we go into it, Ashley, you have a very, very, very interesting background. You've done a lot of things. And, if you don't mind, would you be able to, briefly introduce yourself?
Yeah, sure. So I'm Ashley Baker. I am an attorney out of Pennsylvania. I'm near the Philadelphia area. I started off in the transportation industry as a driver. I got my CDL in 2009. I went over the road for a few years. I taught as an over-the-road instructor. I decided to leave the road to go back to school. So I went back to school, got through undergrad. I decided to go to law school. I also, while I was in undergrad, I taught at a technical college in Georgia. I taught truck driving. So I went to law school, graduated. I went to Southern University Law Center.
Hey, I got a Neo down there right now, and I bet he's living it up.
Okay. Yeah. Baton Rouge was really fun.
Yeah.
And so after law school, I moved to Philadelphia, and, that's how I got to where I am right now.
Okay, bet. So look, what made you want to become a truck driver, at that age? Like, what was going on that said, hey, this is the career path that I'm looking for right now?
At the time, I was a nanny. I wasn't making very much. I liked kids. I liked what I was doing, but I wanted something different. I wanted to travel. I wanted to see the country. And truck driving, I was scared. I'm gonna be honest. I was really scared to go and try to get my CDL. I ended up going with CR England. This is not a plug for them, but I ended up going with CR England. And I didn't know at the time, but they would, send you a bus ticket, pay for your hotel through training. I didn't have to pay anything up front. It seemed like a good deal to me. And so that's what I did. I really just started because I needed a job and I wanted to do something different.
Okay.
So yeah.
Okay. Yeah. I appreciate you going into that. And then you did undergrad in Middle Georgia. That's where I'm from. I went to high school probably about, 30 miles from where you did your undergrad. And not to mention, I went to Georgia State too. So, you know what I mean? Like, it's pretty dope that we have all these similarities. And now I'm able to interview you here on stage. Okay, so I see that you were able to transition from being a nanny to truck driving. You got to see the world, or at least, the United States. So that's amazing. And then went back to school, went to law school, and you had this ability to join this one organization, the American Bar Association. What was that process like?
So I joined the ABA when I was in my at the end of my first year of law school, I applied for a leadership position with them in the law student division. Um, I won. It was an election. I won. And that's kind of how I got involved. I started navigating different areas because the ABA, they pretty much cover every area of law. And so when I found out that they had a committee that was solely about trucking, I was like, yeah, this is my committee right here. This is where I want to be. So, yeah, I've been a vice chair of the Commercial Transportation Litigation Committee for 3 or 4 years now.
Okay. Okay. Do you get to see some very interesting things with that position?
Um, it affords me the opportunity to talk to other trucking lawyers, and to kind of get their perspective on different things that are going on in the industry.
Oh man, that is so valuable, right? Just
Yeah,
to be able to have those folks to be able to speak to, time to time, build those relationships. Just like my folks say, the time to build your network is before you need them. So,
right,
yeah.
right.
So that's awesome. Okay. All right. So we got the background and not to mention the Truckers Law Firm. What is the Truckers Law Firm?
Um, the Truckers Law Firm is my own private practice. I know most lawyers say the law office of Ashley Baker or um, Killam, Baker and Associates, or something like that with their names, right? But
Mm-hmm.
I wanted people to know this is what we do.
Right.
We represent truckers, we represent small carriers, we represent dispatchers, and so yeah, it's my own private practice.
Okay. And I mean, and I kind of agree with you there on the branding. If this was something that we were trying to build to go towards anything, standard, whether it be personal injury or big law, anything with corporate or mergers and acquisitions, okay, cool. Brand it with the partner's name. But if you're in, this type of industry where a lot of stuff is, people want to know what's going on in trucking. I mean, who specializes in this? I think you did a great job of selecting that. I thought that was pretty good, actually.
Thanks.
Yeah. Okay. So no doubt, no doubt, no doubt. Let's go ahead and jump right into this bad boy. So,
Okay.
what would you say? Like some of the liabilities, independent dispatch company like currently faces when booking loads on behalf of a motor carrier, if any? Like, does anything jump out to your mind about the liabilities faced by independent dispatch agency?
So we know that the trucking industry draws in lawsuits. We draw in litigation, just as a whole. And most people think that it's just the driver or just the carrier that is at risk for those types of lawsuits. Well, that's not necessarily the case. Any party in the transport of goods could be called into a lawsuit. That includes dispatchers. It includes carriers, of course. It includes freight brokers. And it could even include a shipper. So it just depends on the set of facts and the things that occur that give rise to the claim or lawsuit. So for a dispatcher, um, it depends because I've seen dispatching services operated differently. So some people, they only book loads for their carriers, and that is their sole task for the carrier. Well, that comes with liabilities too, which I'll talk about. But if you do more things other than that, like if you are involved with the hiring process, if you're involved with giving the load to the driver and not just giving the load to the carrier, because there could be a difference, then that opens you up to more liability. So with hiring, if you choose to help with hiring, which some people do, there's different theories of liability. Mostly in trucking, you're going to see negligence claims. So if someone is hurt by a truck, they're going to bring a negligence action against the different parties to the transaction. If you um, if you don't do a thorough background check or vetting of the driver, and that's the role that you decided to take on for the carrier, then you could be opening yourself up to a negligent hiring claim.
Okay.
Right. Um, and even if the court finds that the carrier is at fault for the negligent hiring, they could seek contribution from you who actually did the hiring. Does that make sense?
It does make sense. Let me
Okay.
ask this, just, to throw out something. What if the dispatcher has a relationship with a separate entity that does exactly that? They find the drivers. They are the recruiting service, and that dispatcher connects recruiting service with carrier or fleet owner. Is there any liability in there, or probably it's just probably a little smaller?
It could be a situation where fault is shared between the parties. So the carrier could seek contribution, but those things go to the importance of having a good contract, having a good um, carrier agent or carrier dispatcher contract. If you have an indemnification clause in the contract that says that, in the case of a claim of negligent hiring, or if the driver does something um, that gives rise to a negligence claim, then that indemnification clause should not absolve you of liability, but it should make it so the carrier can't come after you for that. Does that make sense?
It does. It does make sense. And that word indemnification, it comes up so much in our industry, our field, especially as a dispatcher. You have the indemnification on that dispatch carrier agreement that you just mentioned, and then you have the indemnification on the broker carrier agreement that we're going to discuss a little bit later, and you have the insurance version of indemnification. So it's like that word comes up so much within our contracts and within our business, but I feel like they might mean different things to different people, and I'll go ahead and put
Mhm.
myself out there as a dispatcher. I was once under the belief that when getting a COI, so that certificate of insurance for a motor carrier, and me requesting that they put my name, my company name, Atlanta Dispatch, as the certificate holder, that indemnified me. That meant that, anything that had to do with a claim, they couldn't touch me. But I was corrected, by an insurance agent that basically said, that COI is only good for the day that it's printed, and even then, they can change their coverage that day. So it's not saying that you are protected for anything. It's just more so a verification that they had it created that day to fulfill your request to put them as a certificate holder. So it's things like that I'm learning, and I want other people to understand, so that we can make sure that everybody's operating, in the legal fashion and know what's going on. So we'll get over to the indemnification in the in the broker carrier agreement in just a second. But okay, I do appreciate you mentioning that. And to transition just a bit, we're going to come back to this, but just to transition just a bit, you know, I asked you about the liabilities that the dispatchers face. Now, the FMCSA is currently reviewing what exactly is the role of a dispatcher and what should it be in supply chain. What are your thoughts on that? Where do you think they're going? Do you think it's going to change the way, once they do make their decision, do you think it's going to change the way dispatchers are currently operating?
I do think that there will be additional requirements for dispatchers in the future. So right now, FMCSA is looking at, the role of dispatchers, excuse me, whether they have a place in the industry, how, and if they do, how do we define the role of a dispatcher right now? Public comment is open on the Federal Register for it. I think it's open until July 10th or 11th, for folks to comment on it. I do think that dispatchers will have to probably register with FMCSA just for them to keep track of who is operating as a dispatcher, who's arranging the movement of freight, because the Department of Transportation regulates everything around the movement of freight. So to just have one section of the industry that's seemingly unregulated would kind of be unfair, or at least it's seen as unfair to some people.
I'm not opposed to that. I can see how that can be, and I do see how the way in which the sexiness of dispatching has taken hold of a lot of people. Even for me, I made a mistake. I thought I can go ahead and purchase my carrier MC. I paid that $300 without a clue on how I was going to get a truck. You know what I mean? And then I found out you needed a truck and insurance to get that active. So I said, what are some of the ways with less barriers of entry? And, I found out about dispatching. So I can see how the popularity, people are turning to it. And I can also see how, the way that folks are abusing it, why it needs to be regulated. So I'm not opposed to regulations. I'm just, if I'm being real, I think the comment I'm going to leave in that suggestion box is the fact that dispatchers can work on behalf of one motor carrier. So that's the part that I pray that they leave out. But yeah, I appreciate your. Oh, go ahead.
I think dispatchers do have a role in the industry. That's why I say that I think they'll regulate it and not eliminate it, because if you look at small carriers, most small carriers rely on dispatching. They rely on independent dispatchers to get them freight. Most of the larger carriers, they have in-house dispatchers as employees, so they don't need an independent dispatching services. But a lot of small carriers do rely on that, and because of that, I don't think that there's going to be a significant change. You may have to register, you may have to file some document, but I don't think there's going to be very much change.
True. I mean, and just to think about some of my clients and the clients I've had in the past, as a dispatcher, I started with all box trucks. And to think that, I mean, box truck carriers need dispatchers. The relationships you have to have already intact to get freight consistently as a box truck driver. I mean, some people are out here hitting, but I ain't going to say that's everybody. But you definitely got to be plugged in the game to have those opportunities coming to you. So a dispatcher having, those relationships already definitely plays a part in their day to day, so I agree with you. I think that it would be, I think that dispatchers are here to stay. We do play a very, very pivotal part in the industry. And, I'm just excited to see how it's going to shake out. And, I'm willing to get whatever things they're saying that a dispatcher needs to get in order to operate. So it's going to be interesting, to say the least. And for you, you are on the law side of things. You have people that are able to come to you when they have claims against them, I would imagine. But just to go into it, somebody that's looking to become a carrier, all right, you got to do a couple things. You got to, one, pay that $300 for your MC authority. You have to get your insurance active on a truck, commercial vehicle, whatever you're trying to operate, and you got to get a BOC3 form submitted, which is a processing agent. So for that processing agent, how do they? All right. So please, if you could explain what a processing agent is, and for your role, as the truckers law firm, how do you interact with processing agents?
Okay, so first, a processing agent is just someone within a state that can receive official documents on your behalf. It's much like if you just have, a regular business and they require you to, when you file your LLC, they require you to have an agent for service of process. A lot of people put themselves if they're in their home state because, they can just receive mail at whatever address they're at. But if you're in a business that's out of state, then you're not there to receive whatever official document or court document or summons is being sent to you. So you have to have an agent in every state in which you operate, which means that if you have a truck that's in an accident in a state and you're not in that state, right? You have someone there that can receive those documents for you and notify you that, hey, you received a summons, you received a notice of claim from FMCSA, you received some official document that you need to answer. As far as me as a lawyer, I wouldn't be because I do defense work. So I defend motor carriers, dispatchers, truck drivers. But if a plaintiff's lawyer wants to sue a motor carrier, then they would send service of process, which is just the summons to be pulled into court, or a claim that you had an accident and injured their client. They would send that to the process agent. Does that make sense?
Yeah, it definitely makes sense. If a claim happens in a different state, the carrier's not from that state, but because they got this processing agent, they have someone to receive all official correspondences within that region, and that processing agent will do their job, which is communicate this officially to the carrier, correct?
Right. That's right.
Okay. So yeah, I got that. And with you say that you're more on the defense side of things. So so that means that in order for you to be brought into the picture, that means that the carrier would have already received that correspondence from their processing agent, and now they're looking for somebody to help them. Is that correct?
Correct. So they would contact me or whoever they want to be their defense attorney. They would give us whatever process that they received, their summons and their notice. They would give us that, and then we would, handle it from there.
Okay. All right. So preemptively, right? I know that this right here is a loaded question, so feel free to give what you can, and we don't have to go too long-winded. But what are some of the steps that a carrier can do to prepare for a commercial truck accident? Like, what are the things that you probably have experienced as a lawyer with somebody that needs you to defend them? Like, had they had these things in place, it would have been a little bit easier task. What are some of those things?
Okay, so it's hard to answer that type of question because plaintiffs' attorneys reach for everything when there's an accident, right? So
Right.
so they reach for everything. If I could name one thing that a carrier should make sure is airtight, it's the hours of service and their ELD. You have to make sure that driver is operating correctly. And there was a case, I believe it was in Texas, it was Werner, where Werner was going one way on the highway, a car was coming the other way, there was a median in the middle. The car jumped the median and hit the truck head on. But Werner, the truck, that they hit, was at fault.
Because
Because that driver was in violation of the hours of service.
Jesus.
If you're in violation of the hours of service, a plaintiff's attorney can say you shouldn't have even been at the scene of that accident when it occurred. And had you not been there, like you weren't supposed to be, then the accident wouldn't have happened. So it becomes you didn't do anything to entirely being your fault.
Oh man, that's
Yeah.
wild. That's
Yeah.
wild. And I can see how it is cut and dry. You know, you can't get around it. You're not supposed to be there. You're supposed to be on sleeper berth or doing something. You're reset. You're supposed to be doing something other than operating that vehicle. But what if they said, "Hey, this is personal conveyance"? Would that have mattered?
Um, I don't know if that would have mattered or
Yeah.
not. Yeah.
Because folks out here on personal conveyance any chance they get. So, folks are going to try to get to where they need to be, whether they have the legal hours or not. But okay, that makes sense. That does make sense. Just make sure that you got your ELD tight and you are correctly operating with those hours of service. And you are a former trucker. Are you able to explain to us what those hours of service are, what they look like, and anything like that?
Without going into a whole lot of detail, because it's a few different rules. Just the hours of service are rules that govern when a driver can and cannot drive. I mean, that's pretty much it. They govern when a driver can and cannot drive. Did you want me to be more specific?
Well, my next question was going to be, as a former driver, what were some of the tips and tricks that you might have used to effectively trip plan? So I guess that might kind of go into what the individual rules within the hours of service are. But, I do for the dispatchers and fleet owners and even new owner operators that are going to be listening to this bad boy. You might have some skills that they might not yet uncovered. So, if you did have any of that type of stuff, please feel free.
Okay, so with the hours of service, let me look because I have a book. So
Oh
sometimes
yeah.
I have to reference my own materials. Okay.
I'm not badger.
Okay. So with the 11-hour rule, it's pretty simple. After 11 hours of driving, a driver must complete 10 hours consecutively off duty or in the sleeper berth before they can drive again. There's a caveat to that with the split sleeper berth provision, but just
Right,
for the
right. We don't
most
have
part,
fun.
you have to do 10 hours off duty or in the sleeper. Some people try to run, two ELD logins or back in the old days, two logbooks. And that's where most people, get into trouble with that. Even as a dispatcher, there was a dispatcher that was found liable when the truck driver got into an accident because they dispatched a load when the driver didn't have any hours, even though the driver made his own conscious decision to go get the load when he didn't have any hours. The dispatcher was found liable. So it's not only just important for the carrier and the driver to know the hours of service and to know whether this driver has hours or not. It's important for the person that's dispatching them too.
Right. That's that critical piece right there that people needed to hear. That's the part right there. So please proceed, but you already gave the value of me asking that question.
So another thing when you're trip planning, you want to make sure that you're not just, using the time that you're allotted to drive and also gauging your speed, that you might be traveling. You have to determine whether you're going to be traveling through a state that's only going to let you do 55, like in California or now in some parts of Louisiana. you have to know what the speed limit is going to be. Most people use 60 miles per hour as their method of calculating how long it's going to take them to get to a particular place. I think maybe you should use 50 just to be safe, just to incorporate traffic and all of those kinds of things. Construction in the summertime. But I think that one more thing that you should incorporate is weather. Make sure that you're watching the news. Even as a dispatcher, make sure that you're watching the news. You know, if there's a storm that's going to be in the path of getting this freight to its destination, that can play a key part in your trip planning.
Definitely.
Yeah.
Okay, cool. All right. I think that's some great advice right there. And you mentioned this, but, I'm trying to see if I want to jump there now because it's going to be a full swing of this conversation if I do. Okay. All right. Actually, I'm going to do it. You just mentioned weather, right? You mentioned
Okay.
weather. A dispatcher or fleet owner, a driver, whomever, should be aware of what's going down with the weather. And, there is a part of the broker carrier agreement that does speak to something that does relate to acts of God. Okay. So that clause that's in the majority of them is the force majeure, if I'm saying that correctly. Did I say it right?
Yeah, you said it
All
right.
all right, cool. Can you give us some details on the force majeure and how does that really play its part in the broker carrier agreement?
Okay, so force majeure clause is one that frees both parties of its obligation to perform if what's called an extraordinary event occurs. So it has to be something that you couldn't have foreseen happening, right? So
Right.
so if you want to use like a more recent example is COVID. Nobody foresaw COVID. So a lot of the events that got canceled, concerts and things like that, because they couldn't happen anymore, right? Because
Mhm.
states and local governments were enacting different restrictions. And so if they had those force majeure clauses in those contracts, then they were both, freed of the obligation to perform. They could just, pretty much rip the contract up, right?
Right.
If you don't have that in a contract, there are two ways that you could still not be forced to perform. So, and those would come under the defense to a contract. So there's two defenses. One is impossibility, and the other is impracticability. So, with impossibility, it has to be a situation where nobody could perform whatever it is. Nobody could do it. With impracticability, it means that the purpose of the performance is eliminated. So you entered into this contract to make money. Whatever the purpose is, it's not there anymore. So it's kind of harder to prove impracticability. But there, if your contract doesn't have a force majeure, it's not a lost cause, if that makes sense.
Yes, it does. And just for folks who are listening, the way that plays into transportation is, you sign this agreement, you sign the rate confirmation, and there's probably going to be some type of clause that say, hey, if you don't deliver this by blah, 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 then, you're not going to get paid or, such and such, something of that nature where it's going to say, it's an ultimatum that basically takes away the rate that the carrier will be owed for services rendered. And this force majeure, as she said, frees up everybody if something does happen. So, an act of God, a riot, anything that is unforeseen, just like she said. So that's how it plays a part of our industry. And, so now I transitioned to that because you did mention that weather piece, and now for this, I don't want to say for the rest of the discussion, but for a good amount of it, I do want to go through some of the clauses within the broker carrier agreement, and we can start with something that is very very simple. term. You know what I mean? So a broker carrier agreement is going to have a term. And, when people are talking about the term, what are they talking about, Ashley?
The term of a contract is just how long this contract is going to be in effect. Um, most transportation agreements, even with dispatch agreements, are more long term, like 1 year, and it automatically renews. Most have a notice provision where you have to give some type of written notice if you want to terminate or you don't want to renew the contract. You usually have to do at least 30 days notice. And so, yeah, that's what a term is. A term is just how long the contract is supposed to be in effect.
Okay, cool. And look, I'm just going to give some official verbiage so that people can see how the legalese match up with, the layman's terms that we just discussed. So a clause for the terms would sound like this. This agreement's term shall be 1 year subject to earlier termination for any or no reason by either party giving at least 30 days written notice to the other party sent in accordance with the notice requirements set forth in this agreement of intention to terminate. Absent such notice, this agreement shall automatically renew for successive 1 year periods. So those are all the different facets that she mentioned. It had the notice period, of at least 30 days. It's going to automatically renew, and it's going to be active for 1 year. So that's a normal clause in the terms section of the broker carrier agreements. But the funny thing is, people, I have something similar in my dispatch carrier agreement, and I get way more questions on, what the term means than any other part of my agreement. I'm like, what are you talking about? That's the gimme right there. So,
Yeah.
but yeah.
I think one thing that people should remember is that, like in the paragraph that you read, it says that, notice is to be given per the terms of this agreement or something like that. It said you have to look in another part of the contract to see how the notice is supposed to be given.
Ooh, I'm so happy you said that. Please keep going.
So it may have to be certified mail. It may not be email. So if you send an email and you say, I want to terminate our contract, that may not be sufficient. So you have to make sure that you read all the way through the agreement to see how that notice is supposed to be given.
All right, man, that is it right there. I'm so happy because I was going to have to come back to that, and you just brought it in naturally. I appreciate that.
Oh.
Actually, I had to take that out of my contract, my dispatch carrier agreement, which is the certified mail. I was like, hey, if someone wants to discontinue working with my company, let me just make it easy. We can have, you can send me a text message, but it's just got to be something written so that we have a definitive date. But yeah, that's a very important piece. You got to do it how they're actually asking for within the broker carrier agreement. Okay, so let's go to a different one. All right, so it's something that people maybe not. Folks on the East Coast don't really have to deal with this, but every single broker carrier agreement is going to have some type of information or some clause corresponding with California and their air regulation board. So, Ashley, what is that talking about, and why is it talking about it?
So, like you mentioned, most of these agreements are gonna have that. Most of the agreements are standard, so they're not gonna redraft a new agreement, based on who the carrier is and what their operating radius is. So those that kind of clause is just standard to make sure that that you have to comply with all of California's laws in regards to trucking in that state. So, and I'm not familiar with all of California's regulations because they are a bit different from everywhere else.
Yeah.
But yeah, that's pretty much just what that means.
Okay, long story short, California has way more stringent requirements than that of the federal government. So, they're basically saying if you're going to operate within California, you must have a certain level of, I don't want to say efficiency, but basically your emissions can't be, and your greenhouse gases got to be in a better spot. So the language would sound something like this, and it's a longer situation, so I don't know if I'm gonna read the whole thing. But carriers shall transport. Oh, excuse me. Nope. CARB compliance. Carrier hereby represents, warrants, and otherwise certifies that one, it is aware of, and to the extent applicable to its operation in its compliance with the California Air Resources Board truck and bus regulation. Let me greenhouse gas regulation and transport refrigeration unit regulations. And two, any equipment it uses or operates in California on any of broker shipments shall be fully compliant with all applicable California Air Resource Board regulations, including but not limited to those listed herein. Upon request, a broker carrier shall provide proof of compliance in a form acceptable to broker. So, it's just going to have some type of language that says, hey, if you're going to be going over into California, you would have to be able to pass, their more strict, more stringent regulations. So that might be a reason to deter some carriers from taking a load that does go from, the East Coast all the way to Cali, because you're not technically, your vehicle's not up to where they need it to be. So yeah, that's another clause that is in the broker carrier agreement. Okay, and what about the I feel as though brokers mention this part in their agreement so much that it's the broker's responsibility to bill the customer. The carrier only has the ability to bill the broker. Why are they so matter of fact in there? Like, what is that clause really doing?
I'm not sure, actually.
Okay.
I'm
Okay.
not sure.
Well, I don't mind giving my understanding of what that bad boy is saying, but all right. So look, this is my interpretation of that.
Okay.
It is that you know brokers want to protect their relationships with their customers. They don't want any mixing and mingling between the carrier and the customer because we're going to talk about this in a second, but we don't want any back solicitation. So we want a clean, distinct cut of who is able to talk to the customer. And on top of that, I've actually experienced it where the shippers they don't really like talking to they don't like having to answer to a carrier when they have a broker as an intermediary. They get real sassy and they chew the broker out on the backside of that. So I think it's to protect the relationship while also limiting the additional work and correspondence that the customer might need to do by answering a carrier. So that's my interpretation. If I'm wrong, hey, just let me know, y'all. Just let me know. It's all good. Okay,
So
go ahead.
you did mention protecting their relationships as a reason to include that. Sometimes they do include provisions where the carrier can't discuss what their interactions with the broker, if that makes sense. Hold on, let me see. There was a specific provision.
My bad. Let me ask that. You said that the provision is regulating what the broker can tell the carrier.
No, the carrier can tell other people. It puts
Oh,
them
got
on it puts them on notice that the broker's information is their proprietary information. It's a trade secret. There's
Right.
some language.
Right.
Carrier further agrees and understands that all such records comprise brokers confidential information and trade secrets. Um, so yeah, I just wanted to kind of throw that in there since you did mention them protecting their interests and their relationships.
Oh yeah, no doubt. That right there is the confidentiality clause that, the majority of the brokers are going to have in there. And it's nice when you have the agreements that you're going through RMIS, or, the broker sending to you directly as a PDF that actually has the subheadings. That is amazing because you can see what you're supposed to be looking at before you can expect what you're going to be reading. It becomes a little bit better. But what you just described sounds to me like the confidentiality
Right.
clause. And it's very important. I got that bad boy in my agreement too. And the whole point of me talking about, there's so many different, there's so the relationship of the broker carrier agreement with the dispatcher carrier agreement, they're so closely related. It's the same type of material, just kind of said a different way, but it's the proprietary information that we're really trying to protect. And in some cases, not all cases, but in some cases, it is the person, that is the decision maker that somebody might be made aware of due to the relationship with the person who got them the freight opportunity. So with that, let's go to the non-solicitation. Okay. So non-solicitation itself, would you want to take this one?
Sure. As in just stating what that is?
Yeah, because at the end of the day, that non-solicitation, it goes across the board.
Yeah, so a non-solicitation clause just means that you cannot contact the brokers, shippers, and try to get freight and try to cut them out of any subsequent deals, if that makes sense. A lot of dispatchers add that into their own contracts with their carriers too. But that's just pretty much what that is.
Yes, ma'am. Yes, ma'am. So that part right there is, also, like I said, it's on both the dispatch carrier agreement and broker carrier agreement. And, let me see if I can find some language that actually speaks to that. Soliciting. All right. Nope, not that. Okay. Well, guys, I don't have any specific language that I'm going to read off for that one, but it's going to be very apparent when you're reading it in the broker carrier agreement. It's going to have these elements. It's going to say, hey, any traffic that you learn as a result of this contract, you can't utilize it to then go back to that carrier or that shipper and try to win those lanes. Then it's going to have a penalty for if you do. It's also going to have a time period. So it's going to say, well, you can't go back to these people within, let's just say, 12 months from the end of this agreement, which is the only reason in my dispatch carrier agreement that I have a term, is because it lets folks know when the start of this non-solicitation period actually is from. So it's going to have a period in there, and then it's going to have a consequence, which is, some people, some brokers, is you cannot quantify how somebody else values their relationship. So some brokers just say, hey, 100% of the gross revenue that you receive as a result of, doing these lanes, I want 100% of that, and you owe it to me. And then, some people will say 10%. So you can't judge people on how they quantify their proprietary information, but you do have to be aware of it as a dispatcher. That's one of the clauses that I hone in on the most to see what are their terms? What are they really talking about? And how can I make sure that I'm not out here, back soliciting? Because you'd be surprised. But that's that. And actually, maybe I can
So,
ask you. Oh, go ahead.
so it's good that you brought up that you have a term for how long that clause is in effect. So you said 1 year. It can't be a situation where you put the clause in, but they can never solicit folks that you've solicited before. It has to have some limitation and some scope. In a different industry, it would have to have a geographic scope as well. But, since we're in transportation, then you could be contracting with people all over the country. There was something else that you mentioned too on the back end, and I wanted to say something.
Mm-hmm.
And I totally forgot.
Okay. Look, if it comes back to you, because I have a question for you as it pertains to this, which is, with you being, defending truckers and maybe even your experience by talking to other folks, has there ever been a time that a broker has brought a claim to anyone when it comes to this situation of back solicitation?
I have never handled a claim or had anyone discuss that with me. I've never had anyone handle that type of claim. I would say that if that does happen, you do need to contact a lawyer about it because it may not be an actionable claim depending on how they're trying to enforce it. It's especially as far as the scope goes.
Gotcha. No, it does.
And I remember what I was going to say before. The damages that you mentioned that they can include, you said it was a penalty. That penalty has to be what the law calls a reasonable forecast of what the damages would be to you. So it can't be any number. They can't just put in any arbitrary number. It has to be something that is quantifiable to them. Does that make sense? And it can't be a penalty. It can't really be a penalty. They can't be penalizing you. It has to be a reasonable forecast of what their injury would be if this were to happen. Does that make sense?
It does. And that does give a lot more insight to the way in which I've interpreted because like I said, or, I guess, like I said, is how I believe. You can't quantify how somebody else says how valuable that relationship is to them. But with what you just said, says that there has to be some type of system here that we adhere to because you can't say, a certain amount of money each and every single or a percentage that is arbitrary. Okay, cool. That makes sense. That makes me feel better too. Because, from what I've heard, folks out here, they just trying to make their money. So, I just hope never mind. Let me just stop with that one. But what you did also make me think about is another clause that's within the broker carrier agreement, which is severability. Okay. So severability, which is what you just kind of described of something that, has to make sense and be, it has to be something that's reasonable. And, with the severability, I can give the language, but if you wanted to talk about it first, I'm more than happy with hearing it.
Yeah. So a severability clause is a clause usually towards the end of a contract that states that if any of these provisions are deemed unlawful by a court or are deemed unlawful by a court, then the rest of the contract will survive. So it severs the unlawful paragraph or unlawful portion of the contract from it and leaves the rest of the contract intact, if that makes sense.
It definitely does. That is it in a T. And for that, that language behind it, if the operation of any provision of this agreement results in a violation of law or is deemed unenforceable by any court of competent jurisdiction, such provision shall be severed, and the agreement's remaining provisions shall continue in full force and effect. So no, I think that was a great summation of what that is. But if you see that language, that's exactly what it's talking about. That made me now talk about, it says a competent jurisdiction, a jurisdiction. So we might as well talk about the choice of law and venue. How does that look within a broker carrier agreement?
So usually every agreement is going to have a paragraph or two, sometimes it's not within the same paragraph, that states that if a claim were to arise or if someone wants to file suit, they have to do so in a specific state. Sometimes they may give a city and state. Sometimes they may limit it to whether it's a state court or a federal court in that city or state. And then the jurisdiction clause means that you have to sue and have that lawsuit and this contract be interpreted under the laws of that state. So it could get really complicated, right? So if you have a situation where the jurisdiction is Louisiana
Mm-hmm.
and the venue is Texas, the venue being Texas, meaning that the lawsuit has to be brought in Texas, but it can be brought in Texas. But if the jurisdiction portion of it says that Louisiana's law is going to govern, then you can still have a Texas court interpreting a contract under Louisiana law. That can happen. So it doesn't have to be the same state for both clauses. So it could get really, really tricky. But
Okay.
it's important to have in a contract involving transportation because a claim could arise in any state. Any state the truck travels to, a claim can arise. So it's important to have those in your contract.
Yes, ma'am. That does get tricky. It makes me say, how folks can be licensed and they can pass the bar in two different states. Like, would
Mhm.
it only be those type of, judges and folks that can actually, interpret the other state's laws? Or, I guess it does get tricky. That's just where my mind went just now.
Right, right. Well, um, you can have a Texas court interpreting Louisiana law, as crazy as that sounds. But it's just based on whatever's in your contract and what you agreed to. So
Right, right. Okay. And folks, for that official language, this is going to be something of this. This one right here is not really hard to pick out. Most of the time they say venue. You know what I mean? If you see venue, just know that that's what it's talking about. But, here's some language so that you can relate it. Each of the parties hereto irrevocably, I had to work through that one, and unconditionally submits itself to the exclusive jurisdiction and venue of the states and federal courts serving whatever place that they're serving. So let's just say Atlanta, Georgia, and any appellate court thereof in any suit, action, or proceeding arising out of or relating to this agreement, and further irrevocably and unconditionally waives any claim or defense that any such suit, action, or proceeding brought in any such court has been brought in an inconvenient forum. Each party further agrees that the final judgment in any such suit, action, or proceeding shall be conclusive and may be enforced in other jurisdictions in a manner provided by law. So basically just says whose law is going to reign supreme. And, that's just a very, very common clause within broker carrier agreements. It's in my dispatch carrier agreement too. So again, folks, you got to have both. You got to have both. How familiar, Ashley, are you with subcontracting?
somewhat familiar.
Okay. Okay. Well, that's a huge thing in our industry. That is
Right.
a huge thing. Subcontracting, aka double brokering. Okay.
Right.
So how would that affect somebody, in the law portion of transportation?
Um, I think it would depend,
Uh
right? So if you have a contract that, just flat out says that you can't double broker,
huh.
even though we know that you shouldn't be doing that. If you have an agreement that says that and both parties have signed it and a court upholds that agreement, then, you could be forfeiting, any remedies because there's a there's a particular doctrine called unclean hands, meaning that even if you have a valid claim based on your agreement, then you still won't get anything because you had unclean hands, meaning you did something that was illegal, you did something that was wrong, um, and you knew that's what you were doing. Does that
Right.
make sense?
It does. It does make sense. Okay. And the way that it shows itself in broker carrier agreements is they'll say, hey, without written permission from the brokerage, you the carrier can only transport this cargo on vehicles that are attached to your MC, associated with your MC, your insurance. Anything outside of that would be considered double brokering and or subcontracting. And if that does happen, which it happens all the time, y'all, it happens all the time. Especially with these brokerages that are posting loads on the load board that are based out of California. A lot of times, carriers that are based out of California too. Brokerages say, hey, if you are a carrier and you have a, a home address showing as California, I'm not going to even entertain you because of how rampant the double brokering is. So essentially, they're going to say, hey, if you do double broker this, if you do subcontract this, I'm just going to pay the money to the person, the carrier that actually does the work, that actually, does all the work. I mean, that's why they call it a subcontracting, because somebody is a motor carrier is essentially trying to take money off the top, and subcontract out the work to somebody else. The way that language sounds within the dispatch carrier agreement is carriers shall transport all freight tendered by broker only on equipment operated under carriers for hire motor carrier authority. Carriers shall not in any way subcontract, broker, or arrange the freight to be transported by a third party without broker's prior written consent. If carrier in any manner subcontracts, brokers, or otherwise arranges for freight to be transported by a third party, in addition to any other rights and remedies available to broker may, in its sole discretion, pay the underlying carrier directly, which payment will relieve broker of any and all payment obligations to carrier with respect to such load. So essentially, they're just saying, hey, I just need you to know that I'm giving this opportunity to you. You do not have the right to subcontract it out. And, that's pretty much it. Yeah, that's pretty much it when it comes to subcontracting, double brokering. But it is very rampant. And the reason why we talk about it as, why it's important for dispatchers is if you do see something that's going on where you are picking up a load and then, things just seem sketchy all around, from the interactions with the broker to the type of agreement that they're asking you to sign to the rate con being a little bit shady. And here's the kicker. If your carrier actually does, somehow make it to the shipper and you see that the BOL has another broker's name as the carrier, or another carrier listed as the person that's supposed to pick it up, just make a couple phone calls, find out who the load originally belonged to, and see if this is that situation. It doesn't take too much work, to be honest. And once you're successful with doing it, you're going to get a little bit more money anyway. So, just do your part. Just do your part. So yeah, that's double brokering. That's subcontracting. What else? I mean, I feel like with the broker carrier agreement, there are at least 35 standard clauses. You know what I mean? So I don't know. I don't want to hold you up this whole night, Ashley. Did you have any other ones that you just wanted to talk about specifically?
Yeah. So I was reading through one today. There was a clause that kind of jumped out at me. It says carrier hereby waives its right to obtain copies of brokers' records.
Yes, ma'am. Yes, ma'am. See, you're
Um,
here. I was going to ask you that. All
and
right.
so then it cites a federal statute where that pretty much just states that a broker has to maintain records of its transactions. I think it's for a period of 2 years, but I'm not sure. And anybody that is a party to transactions with that broker has a right to obtain that information. Anytime that the Department of Transportation or the federal government says that you have a right to these records, it's likely because something shady went down with someone in the past. So there's usually a good reason. So anytime I see something where you're waiving your right to get information, that's a red flag for me. There was another
Well,
clause.
let's talk about that one just a little bit before we go to the
Okay.
next, because I do think that is very important. I'm going to read the verbiage so people can become familiar. But my interpretation of why a brokerage would be asking a carrier to waive that right is because they don't want the carrier to know how much the carrier got paid compared to how much the broker got paid. Those are the two fundamental things that I think are to be protected. Aside from that, maybe the customer information, but at the end of the day, I do think it's going to be the amounts, and how if a carrier knew exactly how much was being paid for a particular lane compared to how much they were getting, they would protest and want to be able to make more on the next time they did the lane. So I feel as though it just gives the carrier a little bit too much power in that. So that's my interpretation. What was that next thing? Oh,
Um,
I can go ahead and read that clause so people can understand what we're talking about, and
okay.
that is carrier hereby waives its rights to obtain copies of the broker's records. You know what I mean? It says it as plain as day like that. As provided for under 49 CFR Part 371, notwithstanding the foregoing, to the extent that carrier obtains records set forth in 49 CFR 371.3 by any means whatsoever, carrier agrees to refrain from utilizing such records in negotiating for the provision of services with any third party, including existing customers of broker. Carrier further agrees and understands that all such records comprise brokers' confidential information and trade secrets. Nothing in this section is intended to relieve carrier of any other obligations imposed upon it by this agreement, or to limit any rights of broker to enforce such obligations. So, just be mindful of that when you're signing these broker carrier agreements. Although, and this is what I've learned, although that this might be standard language for somebody, um, sometimes you can actually say, I don't want to sign that. They can say, I have my set rates for detention. Well, these are my set rates for detention, and you can kind of maneuver like that sometimes if you know the weight that you're working with as a carrier. So Just know that if you're listening to this. But Ashley, go ahead with that next one.
This one was really short. Carrier agrees broker at its option may offset against any payments owed to carrier against, I'm sorry. I'm going to start over. Carrier agrees broker at its option may offset against any payments owed to carrier amounts carrier owes to broker under this agreement. I
Right.
think I think that coupled with the provision that you just talked about or that we just talked about, limiting your access to information could be problematic to a carrier.
Definitely. I certainly agree with you. That right there is not something that I would say is normal. That I don't think that agreement is normal actually. And maybe it slid by, but I don't the whole point of a dispatcher going through and signing these broker carrier agreements on behalf of motor carriers is that we point out and react to stuff that doesn't seem right, stuff that just seems a little bit too negligent, I guess you would say. So and this is a major broker. I can't even say the broker because we're over here reading their information, but this is a major broker who does hella business. So just it does suck. Hopefully, folks can avoid signing some of these things. I don't really know what to say about it. Ashley, what do you have to say about it?
I just think that the two clauses together are problematic because you want to have a free flow of information. And so let me go back to the clause. So if they are saying that they can offset against any payment that's owed to the carrier, and you have a restriction of information that the carrier can have access to, that just says it's something's going to happen. It's going to be a problem.
Right, right.
You know.
Okay. Oh yeah, I certainly thank you for bringing that up. Look, if there were any questions, now is definitely the time to ask them. Ashley, are you okay if we leave that open for about 30 seconds if people wanted to raise their
Yeah.
hand?
Yeah.
Okay,
Sure.
cool. Well, look, 30 seconds. Boom. If y'all have any questions, please go ahead and raise your hand. There was one question in the chat that said, hey, do you have anything that you will look out for if you're allowing folks to lease on to your company?
As a carrier, right?
Yeah, as a carrier.
Um, what I look out for. That's a lot. I think you need to just make sure that you're doing business with a reputable company that you know about this person's reputation as a driver, um, that that you trust them. It shouldn't be like a situation where you just met someone and hey, I'm gonna let you lease onto my company. Um, you want to make sure that you know them, that you trust them, because things can go bad very quickly. Um, but that would just be my 2 cents.
Okay. Well, yeah, I appreciate that. I think that, that it's a very, you get intimate as a fleet owner that allows somebody to lease onto your company. It becomes a very intimate relationship. Whereas you want folks that are going to make your business better, not create dirty laundry for you. You know what I mean?
Right.
So you did hit it on the head. You do want it to be some folks who are reputable and very qualified. So I appreciate you mentioning that. And if there were any other questions, please feel free to, just reach out to Ashley. Ashley, you got a couple books, don't you?
Oh yeah, I do. So I've authored a book series called The Art of Commercial Trucking. It has different, each book has a different topic. I have a dispatching book and workbook, a hours of service book, a trip planner, where, you can, it has different prompts on each page that, let you put your bill of lading number, your pickup information, your delivery information. Each trip planning page has an accompanying notes page so that if anything happens on that trip, you can just write it right there. Where it is. You can just flip to it. I also have a CDL Class A permit workbook. So if anyone's trying to get their CDL and they need something to help them study, it has over 300 multiple choice, true, false, and fill in the blank questions with the answers in the back, and also a over 100 term glossary of different trucking terms. Because people who are trying to get their permit are usually new to the industry. So yeah, that's just what I have. You can find the books on theartoftrucking.com.
All right, theartoftrucking.com. And we do also have the truckerslawfirm.com. And yeah. Well, look, Ashley, I just want to say thank you so very much for joining me today. We discussed a whole bunch, and I pray that we're able to revisit some of these conversations soon. Maybe after the FMCSA makes their conclusion, and we can ask you about your interpretation of everything. How does that sound?
Sounds good to me.
Okay, well, bet. Again, well, I appreciate you, madam. And everybody, y'all have a blessed day. Join us on Monday, 7:30 a.m. We're going to be doing the Transportation Logistics Clubhouse is going to be partnering with Freightway, Sonar our team, to talk about where you should send your trucks to start the week and places you should avoid. And next week, we're going to be discussing a fleet owner. It was a brokerage first, and then, they just opened a sister company that has trucks. They're seeking owner operators to lease on to them because they have hella lanes. So if you are interested in that, come join us next Wednesday, 7 p.m. on Transportation and Logistics Clubhouse. Well, everybody, be blessed. Thank you again. Ashley, you have a good one.
You too.